I think we got everybody. All right. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation of evictions and knowing your rights. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included, we have the City of Houston's Department of Neighborhoods, and also joining us on behalf of our presenting partner today with Lone Star Legal Aid, we have Ms. Sapnia Ayers, who's going to be presenting the information for you all today about evictions and tenant rights. But also included in our partnership, we also have the Harris Central Appraisal District, the Earl Carl Institute, Texas Legal Services Center, Houston Volunteer Lawyers, and the Harris Central Appraisal District. Um, did I say Houston? Yeah, in Houston Volunteer Lawyers. I think I said that already. But together, collectively, we make up a month of service. And basically, a month of service is the collaboration of all of our organizations coming together on a monthly basis and offering a variety of different workshops, resources, and information for the community that generally don't have access to a lot of information or don't know where to go for a lot of resources, especially those that as it relates to asset building, asset protection, community empowerment, and the maintaining of generational wealth. As of late, there has been an abundant amount of evictions that have been happening, and there's a lot that's going on. I know that there's a lot of people that are still experiencing a lot of financial hardship and that are potentially or could be facing eviction. So we wanted to make sure that we have the most up-to-date information um, uh, as things change, as laws change, as processes change, so that the tenants or renters are aware of what their rights are and what the processes actually are. You'd be surprised as to how many people really don't know what the actual eviction process is like. You know, once they receive that notice to vacate, that they think that means, okay, I got to go. I'm being put out. I have no other options. I have no other choices. But we're here to just kind of make sure that we set the record straight and again make sure that everybody is informed and aware of what their rights are. So we do encourage you to share this information with others or other renters, family members, coworkers, or whomever that you may also feel like this information could be beneficial to them. We try to do this presentation at least once a month. The third Tuesday, sorry, of each month is when we do this. Again, we try to get the legal experts in those areas to provide you all with the most accurate and up-to-date information. We know that there's a lot of information that's kind of out there floating around on social media, on TikTok, and things like that, where people are just kind of giving blanket statements about evictions and this, that, and the third. But a lot of things don't necessarily relate to the laws in the state of Texas. So do know that the information that does get presented here, it is relative to the entire state of Texas. It is not just for the city of Houston or Harris County. So wherever you're viewing from, know that it's information that's relative to your area and also to the state of Texas. We do generally get people that kind of tune in from all over different parts, but the legal presentations that we do only relate to the laws in Texas. So do keep that in mind. In addition to that, I also want to say that information that does get presented here is for educational purposes only. It is not to be considered any legal advice. However, we do encourage you to reach out to our legal service partners like those at Lone Star Legal Aid if you do find yourself in need of any civil legal assistance. And Sopna is going to kind of go over a couple of other little things about Lone Star and the other services that they offer or the areas of service that they also provide. So also know that we do record this session and do broadcast live on our social media platforms. So this is your opportunity to ask whatever questions that it is that you may have. However, we do want to inform you or remind you that we do record and then we do broadcast live. So we want to try to protect your privacy as best as we possibly can. So we ask that you try to keep your questions to be general in nature and not real specific to your particular situation. One, because again, we want to try to protect your privacy. We don't want anybody saying, I live at such and such address, or I'm having an issue with this particular landlord in this particular neighborhood, and that kinds of things. And also, there's a limit of information of what it is the attorney can actually answer when it comes to real specific questions. So that gets into that attorney-client kind of privileged thing. So there's a lot more information that will be needed to answer real particular, real specific questions. So do keep that in mind. But you do have the opportunity to type your question into the chat. If you are joining us from our social media platforms, I am monitoring the chat or the comment section there. So if you do have questions, please feel free to type your question into the comment section. If you are joining us on Zoom, feel free to type your question into the chat box or unmute yourself at the end of the presentation, and then you can raise your hand or ask your questions directly. But so do just keep that in mind. So as we're moving along, know that we will get to the questions at the end of the presentation. There will be a lot of information that's going to be covered here today. We do hope that you all receive the information that you did come here to receive. If there are additional questions that you have afterwards, please feel free to reach out to myself, and I'll make sure that the questions get forwarded or apply for the services with Lone Star Legal Aid to speak with an attorney there as well. But the information, any resources that get provided here, we will make sure that that information is shared with you all. Any kind of programs or anything that kind of come up throughout the presentation, we'll make sure all of that information gets sent to you guys as well. So with that being said, I'm going to have Ms. Sapna go ahead and introduce herself, and then we will get right on into our presentation. And again, I want to thank you all for joining us this afternoon, and we appreciate you for being here and continuing to support this A Month of Service collaboration. So without further ado, Ms. Sapna Iyer we'll start the presentation now.
Hi, everybody. My name is Sapna Iyer. I am the directing attorney for the Houston units at Lone Star Legal Aid. Let me go ahead and share my screen here. Okay. I am not Benjamin Daly or Kim DK. I am covering for them as they are in court today. Lone Star Legal Aid is a nonprofit law firm. We have been around since 1948, where we initially started as a legal aid clinic, merged with East Texas Legal Services in 1977. Our primary office is in Houston, although we do serve 72 counties in Texas. You do have to apply for us and you do have to qualify. We serve low-income individuals, so you do have to go through a process and qualify for us. You can apply at lonestarlegal.org, or in Harris County, you can call 713-652-0077. I just want to repeat, even though Nia already said it, that this presentation is for information only. We are not your lawyers, and nothing in this presentation is designed to give you guys legal advice or create any kind of attorney-client relationship. All right, so this is kind of the agenda. We'll go through all of these things. We're going to talk about leases, notice to vacates, the evictions, appealing. We're going to touch a little bit on public housing. There are a few different rules when you have public housing versus what we call private housing. We're going to talk about lockouts and your utilities being cut off, and we'll talk about security deposits. The information is present through the end of 2025. As you may or may not know, there is a new law that just passed that will come into effect next year in 2026. And at that point, we will update this presentation with the current information on the new law. But for right now, today, this is the law that is in effect. All right, so your lease. Your lease is an agreement between your landlord and you that establishes the rules about your dwelling. It's going to say what you can and cannot do. It's going to say when your rent is due, when you have to pay it, how you have to pay it. It's going to talk about whether you're responsible for your water and your electricity, or maybe it's just one, whether or not there is a trash service, all of those kinds of things. Bottom line is your lease is a contract, and you are entering into a contract with your landlord. Texas allows for both oral and written leases. So if you have an oral lease, do the best that you can to document the terms of the lease, whether that is text messages or emails, something that shows when your rent is due, how much your rent is, whether you're required to pay utilities, whether you can have a pet, whether you have a parking space. All of those kinds of things are issues that come into courts when people are fighting about oral leases. If your lease is for longer than a year, the agreement does need to be in writing. You have a right to get a copy of your lease. So within 3 days of the lease being signed by parties, the landlord should give you a complete copy of your lease. Double check to make sure if you're missing a copy of your lease that it's not sitting in your portal. A lot of times, all of your documents are going to be sitting in your rental portal, but you do have the right to ask for a copy of your lease. And if you didn't get a copy of it, ask for it in writing. Just a general rule of thumb. Whenever you are dealing with your landlord, put it in writing and keep a copy for yourself. Everything needs to be in writing and it needs to be dated. Know the terms of your lease. Know what your rent is, when and where to make your payments, how much your late fees are, how your payments are applied. We hear time and time again, my rent isn't due until the 3rd. Your rent is due on the 1st, almost always. Typically what happens is a landlord won't charge you fees until after the 3rd day. That doesn't mean your rent isn't due on that 1st day. They will typically also apply your payments to all of the fees and charges first and then to your rent. So if you pay your rent late on the 8th, there's going to be a late fee that you have to pay. Well, when you pay your rent next month, they're going to pay that late fee first, which means the amount that you paid in rent doesn't actually cover everything that you owe. So it's important, if you fall behind, you do your absolute best to catch up because they will pay off those fees first. Your initial term, anywhere from 1 month, sometimes we see 18 months, sometimes we see 2 years. So double check the initial term on your lease. Sometimes the lease will say when it ends, it automatically goes to a month to month. I have seen some leases that say that if you don't renew, it'll renew automatically. So again, you're going to want to check and see what your lease is like. There are always some sort of community rules and policies. These are going to be things like what you can do in the common areas, if there is any kind of event room, how you would rent the event room, for example. Smoking, typically you cannot smoke on the ground, so it'll have designated smoking areas. It'll have policies about noise, right? What are the quiet times on your complex? Typically they're, 7 to 7, 10 to 7, something like that. You're going to want to double check. There'll also be policies about parking. Where are you allowed to park? Do you have a designated parking space? Where can your guests park? If your guests park somewhere, will they be towed? All of that stuff is going to be in your rules and policies. If you have any kind of housing, there's going to be an addendum. The addendum will cover things like what the housing authority is going to pay, what your share of the rent is going to be. There'll be something about concessions. So did you get a move-in special of any kind? That will also all be in writing. Acts of default, these are things that typically lead to evictions or notices of defaults of some sort. The big one is failure to pay rent. Like I said, your rent is almost always due on the 1st. They will start assessing late fees on the 4th. If you don't pay your rent, you are in breach of your lease, and then landlord has the right to evict you. Material breaches, these are really big violations of your lease. So if you did something that isn't a big violation of your lease, not like you put your trash out a day too early. But if you had a really big fight in your apartment and there were holes in your walls, those kinds of things can be breaches of your lease. Early termination or holding over. So if you leave early, or if you stay after your lease is over and your lease has not been renewed, that's going to be a holdover. That is a violation of your lease. You're going to want to double check, when do you have to renew your lease? So most of the time leases will say if you want to renew, you have to give us 30 days notice. Sometimes it's 60 days notice. Sometimes it's even 90 days notice. So if you want to stay where you are, you need to double check and see how much time you have to give the complex to ask them to renew your lease. Notice to vacate and notice of default, we'll go through this a little more. There are specific timelines when your apartment is giving you notices, asking you to leave, or notices saying that you've defaulted on your lease. Terminating your lease. So after the initial term, both the landlord and the tenant have the right to terminate the lease with proper notice as to what is in the lease. Your lease will have language talking about when you or your landlord is going to end the lease. So for example, if your lease ends in December, your lease will say, you have to give the landlord notice that you would like to renew your lease. And you have to give that to your landlord October 1st, for example. But at the same token, your landlord will also have to give you notice that says we are not going to renew your lease. So typically there are very strict dates when you or your landlord have to let the other party know if you plan to stay in the apartment. If you don't leave when your lease is over, you are a holdover tenant. Except in very special circumstances, you cannot make your landlord renew your lease. You cannot make your landlord let you live in an apartment complex, just like your landlord cannot make you live in that apartment complex. Remember, at the end of the day, this is a contract. And when the contract is over, your rights to be in that apartment are also over. If you terminate your lease during the initial term, which is usually a year, that's an early termination of the lease. So if your lease is over in December and you try to leave in October, you will typically have to face fees and penalties, probably a break lease fee, some sorts of fees for the unpaid rent, but there is always going to be something that you owe the landlord for leaving early, except for a couple of special circumstances, which we'll talk about later. All right here, your rights to early termination. In very specific instances, you can ask the landlord to terminate your lease and you can leave without liability. So family violence, if you're in a domestic abuse situation, you have the right to get out of your lease early. If you are being stalked, you have the right to get out of your lease early. If the tenant passes away, typically they cannot charge the tenant for rent after the person passed away, but if they owed rent when the person passed away, they can go to the estate to try to get that money. If you're in the military, if you're being deployed overseas for a year, typically you can get out of your lease. There are very specific things you have to do under every single one of these statutes. Typically, there are notices you have to give. Sometimes you have to talk to the DA. Sometimes you have to get a protective order. So you're going to want to look at these statutes if one of these applies to you. And TPC is the Texas Property Code. You can go to Texas Legislature online and pull up every single statute. So it's the Texas Property Code, and these are in section 92. You also have the right to early termination if there is a casualty loss. So casualty loss refers to insurance. So for example, during Harvey, we know a lot of apartments flooded and they were made unlivable. So if there is a casualty loss, think Harvey, and the loss is not the result of the tenant, well, nobody was responsible for Harvey. The Texas Property Code 92054 gives tenants the rights to terminate the lease. It also gives landlords the right to terminate the lease once the property becomes completely unusable. Now that phrasing is actually pretty important because if your apartment is only a little bit unusual, the landlord cannot make you move out. And you, as the tenant, have the right to ask the court for a reduction in your rent. So if you have a 3-bedroom apartment and you're paying $1,500 for it, and Harvey ruined one of the bedrooms, but the other 2 bedrooms and the kitchen and the bathroom are all right, the landlord doesn't have the right to make you move out for the loss of a single bedroom. You have the right to go to court and ask for a reduction in rent for the single bedroom. Again, this has to be a casualty loss and it cannot be anybody's fault. So if the reason your bedroom is flooded because you flooded the bathroom, this does not apply here. And it can be waived or altered by the lease. So again, you're going to want to make sure that you read your lease and see if there's any changes to this provision. Review the property code. The statute will tell you what kind of notice and documentation you have to give to your landlord. Okay, termination of the lease due to the breach. This is kind of the common one. This is what you're going to see in eviction courts the most. Any violation of the lease terms, conditions, or rules, your lease will tell you what is a breach. So again, before I had talked about you have a big fight in your apartment and there's holes in the wall, right? If you have a history of really loud parties every Friday night and the cops are called out to your place every Friday night, and this happens for several months, that is going to be a material violation of your lease. If you have a pet and you're not allowed to have a pet, that could be a material violation of your lease, depending on the type of pet that it is. A goldfish, probably not. 2 giant dogs, possibly. So common default by resident terms, the first one, the most common one, is that you don't pay your rent by the date stated in the lease, or you're always paying rent late. Once you pay your rent late, you are in default. Repeated violation of community policies. If you can continue to smoke in your room, even though you've been told continually that you cannot smoke in your room, that's going to be a repeated violation. Unauthorized tenants. If you have people living with you that are not supposed to be there, that is a common violation. Criminal activity by the tenant, occupants, or guests. So if you are committing a crime, if people living with you are committing a crime, if your guests are committing a crime, depending on what has happened, you can be held responsible. And then holding over. So if you're staying in the apartment once your lease is over, that is a default. Now, before your landlord can evict you, they have to give you proper notice. We'll talk about that in a few minutes. I do want to touch on withholding rent. We have a lot of clients that call us and say, the landlord wouldn't fix X. My dishwasher, my toilet's running, my tub is leaking. My air conditioning doesn't run cold. It's always 85 degrees in my apartment. And they decide to withhold the rent because their landlord hasn't fixed those things. Don't do it. Never withhold your rent in Texas. Always, always, always pay your rent. Texas law requires your rent be paid in full and on time as it comes due. If you withhold your rent, your landlord will evict you for non-payment of rent. In order to get repairs to your unit, you have to be current on your rent. I'm going to say that again. In order to get repairs to your unit, you have to be current on your rent. As soon as you stop repairing your rent, your landlord does not have to fix your apartment. And this includes things like pests and rodents. If you stop paying your rent, your landlord does not have to fix your pest problem. If you're having issues obtaining repairs, send your landlord a certified letter saying, this is what needs to be repaired. I'm asking you to repair it. And then contact a legal professional. There are ways that you can force your landlord to make repairs. There are protections that you have as a tenant who is current on their rent by following the property code 92056. However, this section is pretty hard to follow, and I've never seen a tenant do it properly by themselves. So again, do not withhold your rent. If you're having problems getting a landlord to fix your apartment, first pay your rent, then send your landlord a request in writing by certified mail, and make sure you review this property code provision. There are some cases you try to pay your rent and the landlord decides not to take it. The landlord is not allowed to not take your rent. That is actually a breach of the contract, right? Your lease is a contract. You agree to pay on the 1st. Your landlord agrees to accept your rent on the 1st. But if your rent is late, or if it's only a partial payment, or if your lease is over, then your landlord does not have to take your rent. The landlord can also determine how you pay your rent. So if you have to pay by going into a tenant portal, then that is how you have to pay. If you've tried to pay your rent and your landlord has refused, first, make sure that what you're offering to pay is everything that you owe your landlord. It's not just the rent, but it is rent plus any kind of late fees or charges. Document the date and the manner of the payment, document correspondence with the landlord, keep the payments for the funds. You're going to need those funds because when your landlord turns around and evicts you, not only are you going to need proof that you tried to pay, you're going to need to have the money available. Judges do not look kindly on landlords that simply refuse to accept the rent. Continue to offer the rent in full and on time. If you need a witness, take a witness with you. If you need to record yourself trying to make the payments, do that. Take pictures of being locked out of the portal. If you're still having issues, we advise you to seek legal assistance. All right, this is the notice to vacate. In order to begin the eviction process, they have to give you proper written notice. The Property Code 24005 explains that the notice has to be in writing. You have to give at least 3 days unless the lease allows for a shorter period. Make sure you check your lease because you can contract for as short as a 1-day period. Most notices we see are the 3-day notice. There are specific ways they have to deliver the notice. It can be in person, hand delivered. It can be sent by regular mail, registered mail, or certified mail. It can be posted on the inside of the front door. The inside of the front door. This doesn't mean they can walk in and just throw it into your apartment somewhere, okay? It needs to be posted on the inside of the front door, taped to your door. As an alternative, in an envelope affixed to the outside of the door. So if you have notice on the outside of your door, take a picture of it before you take it down, because you'll notice it says it has to be in an envelope. If it's not in an envelope, they didn't do it right. The landlord has to prove up why they did it this way, because this is supposed to be as a last minute, a last circumstance, right? A last alternative. Why didn't they knock on your door, open the front door, and tape it to the inside of your door? Why did they stick it on the outside? The landlord also has to show that they mailed a copy to the tenant by placing it in the mail before 5 on the same day. So you should be getting a letter from your landlord postmarked before 5 p.m. on the same day. So make sure you keep that envelope. Double check to see when it was dropped in the mail. There is a CARES Act possible defense. Under the CARES Act, if you are what is called a covered property, the landlord is required to give you a 30-day notice to vacate. The covered property are properties that are linked federally. They get some sort of federal funding. So typically, we will see Violence Against Women's Act. We'll see public housing, Section 8, housing choice voucher, rapid rehousing, low-income tax credit properties. There's more, but these are the ones that we see the most. If the complex has a federally backed mortgage, this is getting into the weeds a little bit, but if the apartment complex has a mortgage on it and that mortgage is held by a federal or semi-federal entity, these are the ones we see the most, you are required to get a CARES Act notice giving you 30 days. It does include single homes, family homes, duplexes. For larger properties, there are ways that you can actually check to see if the mortgage is with Fannie Mae or Freddie Mac, but all the databases have been updated. You can also check real property records. Property records are public, and so you can check those. If you're in litigation, your attorney can ask for those through discovery. So evictions, the primary focus is to deal with the right of possession. So who gets to have the space, basically? Who gets the keys? The main elements are the plaintiff has to prove they're the owner, right? So you don't want someone who doesn't own the property trying to have possession of the apartment. That doesn't make any sense. There has to be a breach of the lease or termination at the end of the lease. Most of the times, what we see are breaches of lease for non-payment of rent. They have to give you proper notice. This is that notice that we talked about earlier. It's almost always 3 days, and they have to have delivered it to you properly. And you have to have refused to leave. So you got the notice and you decided to just stay there. Pay attention to the date the lawsuit was actually filed, because again, proper notice requires typically 3 days, unless you're a CARES Act property, and then they have to give you those 30 days. If you're dealing with non-payment of rent, typically the landlord just wants possession of the unit, but they can add a claim for back due rent. The landlord can only ask for rent. That's an important distinction here. A lot of times landlords will ask for rent plus late fees or utilities or other sums. They're not allowed to do that in an eviction. They have to file another lawsuit, typically in small claims court, to get that extra money. You do have the right to ask for a jury. You do have to do it timely, and you have to pay the fee for a jury. Evictions happen in justice court. They are simplified. They use simplifies procedural rules. They are designed to be utilized by people who are not attorneys. They don't follow rules of evidence, and so they differ greatly from court to court. In some court, the judges themselves will ask you questions. In some courts, they just kind of let you go at it until they get the information they need. In some courts, the justices have already gone through the eviction file to determine if everything they need is there. And if something's not there, they will ask the landlord for it themselves. So every court is different. Arrive on time and have everything that you might need for trial. If you are being evicted for non-payment of rent, you're going to want proof of your payments. If you've been trying to pay your rent and the landlord wouldn't accept it, you're going to want that proof that you tried to pay it and the landlord wouldn't take it, right? You're going to want that witness there. You're going to want those emails. You're going to want mail returned if you sent the rental checks in by certified mail. You're going to want proof that you were blocked out of the portal. Some judges give instructions on how the court works prior to calling the case to trial. Some don't. So I recommend that you always go a little bit early and you sit in the courtroom and you watch, so you know how the court operates the trial, so you know what to expect. Judges generally begin by hearing the plaintiffs first, so the landlord is going to go first, and then the tenant is going to go. Be prepared to answer the judge's questions and provide evidence of your defense. Trial can only be reset by motion of the plaintiff if both parties agree to the continuance. So if the plaintiff asks for a week delay or a 2-week delay, you have to agree as well. At the end of the trial, the judge will issue a judgment in favor of one party or will dismiss the case. So the landlord could win, the tenant could win. The judge could also just dismiss the case, which means something was done incorrectly. A lot of times this would be because the notice wasn't done correctly. And so the landlord in those cases, a lot of times will turn around and refile. Always get a copy of the judgment for review and for your own personal records. Always be respectful to the judge, the court staff, and the opposing party. Dress appropriately. Do not wear open-toed sandals or flip-flops. Don't wear t-shirts with writing on them if at all possible. Your pants should be below the knee. You shouldn't have rips in your clothing. Dress appropriately when you're going into court. Some judges encourage settlements between parties or provide resources to facilitate settlements. So sometimes there's standard forms and sometimes there's mediators. And a settlement requires both parties to agree to your specific terms. So typically what will happen is you'll go into a room with a mediator and you will sit there and the landlord will sit there and you guys will talk about whether or not there's something that you can agree on, right? Landlord, if I agree to move out in 2 weeks, will you dismiss the lawsuit? Sometimes they will. Sometimes they know that if you appeal that you'll be in that apartment longer, and 2 weeks means a shorter amount of time before they can have possession of that unit, right? Landlord, I just got a new job. I know that I can catch up my payments if you'll just give me 10 days. Sometimes they will. Sometimes they won't. Sometimes they'll say no, but sometimes they do. Landlord, I've just applied for rental assistance. Will you agree to a 2-week reset to see if it'll come in? Sometimes it will, sometimes it won't. But this is where you can kind of go into a room and decide and see if there's something that you guys can agree on to get the case dismissed. Settlement needs to be in writing and signed by both parties and will be filed with the court. If it's an informal or unwritten agreement, it's not enforceable by the court. So the reason you want it in writing and filed with the court is so the court can hold you both to the terms of the agreement. If the agreement is, I'm going to pay all of my, all the money that I owe in 10 days, and then you're going to dismiss the case with prejudice, which means you can't refile it, and then you do that and the landlord doesn't dismiss the case, you then have something on file with the judge to say, hey, judge, I paid all my money off. This is supposed to be dismissed. And then the judge can dismiss it with prejudice according to what is on the agreement. Sometimes the settlement agreement involves parties giving up rights. Sometimes it imposes penalties if a party doesn't comply. So make sure you know what you're agreeing to, make sure you understand what you're agreeing to, and make sure that you can do it. We see a lot of aspirational settlement agreements. I will pay all the rent that I owe plus $200 in 13 days. Meanwhile, the tenant doesn't have a job, right? Oh, how are you going to do that? But they signed that agreement. Or I'm going to be out in a week, but the tenant doesn't have anywhere to go. So make sure that if you sign an agreement, it is something that you can do. The appeal process. Within 5 days of the court date, and this is in justice court. Remember, evictions take place in justice court. If you lose, well, whichever party that loses can appeal. Tenants can appeal by filing a statement of inability to afford costs. You can get that form from the clerk. You fill it out completely under oath, and you return it to the clerk. If you do not appeal the case, you have to vacate within 5 days. Otherwise, the writ of possession can be issued. So again, the magic number, if you're being evicted because you didn't pay rent, you then have to pay rent into the court's registry. So again, the magic number is 5 days. The case will then be sent up to the county court at law and assigned to a court. You'll get paperwork in the mail, so make sure you're checking your mail. And you don't need to file an answer because your statement of inability form is your answer. If you appeal using the inability form, you have to pay your rent as it becomes due. Typically, this is the first of the month. Sometimes that means you do have 2 monthly payments due at the same time, because if your eviction hearing is on the 20th and you lose, you have 5 days to appeal. So let's suppose you appeal on the 25th. Well, your rent is due on the 30th, right? Because it's 5 days to appeal and then 5 days to pay your rent. Well, your rent is also due on the 1st of the month because rent is always due on the 1st of the month. So unfortunately, depending on when your eviction falls, you might have to pay 2 rental payments back to back. If you don't make those rental payments, the writ can still be issued against you to have the constable come and remove you from the unit. Now, that doesn't mean your case won't be sent up to trial in the county court. It just means that you won't be in possession of the unit anymore. When you're in county court, it is what is called the de novo hearing, meaning it is from the beginning. Nothing that happened in justice court matters. It's as if the justice court did not exist. So there's no reason or need for you to tell the county court judge what happened last time, because what happened last time doesn't matter. However, when you are in justice court, pay attention to what your landlord is doing, because they might very well do the same thing in county court. And this time you'll have a little more idea and maybe be able to prepare for when you go to county court. The landlord has to prove their case with testimony and evidence. County courts are what we call a court of record. And so the rules apply. There are formal rules of civil procedure and there are formal rules of evidence. If the tenant loses in county court, you have 10 days to pay the appeal bond, but the writ of possession can still issue in 5 days. The cost of an appeal up to a court of appeals in Harris County, this is either the 1st or the 14th, is usually 10 times the monthly rent due in a lump sum. And some courts will allow for an immediate writ of possession after trial if you don't make your monthly rental payments. There are some specialized rules for public housing and subsidized housing. Section 8, low-income tax credit. There's additional termination requirements. If you have a HAP contract, this is between you and the housing authority typically. There are additional requirements. Public housing beneficiaries, don't forget, are covered by CARES, so they get that 30-day notice. And people that are in public housing and get rental assistance through their public housing are only responsible for their portion of the rent. So if the housing authority is paying $700 and your portion is $200, when you appeal, you are only responsible for that $200. The terms and protections differ between the programs, so make sure you are familiar with the rules that govern your program. Sometimes you are required to get 2 notices, sometimes they are required to meet with you, sometimes they are required to offer you chances to catch up. A lot of programs have recertification requirements that you have to meet, so make sure that you double check your own rules for whatever program you are on to see what kind of protections you may have, in addition to what we've already talked about. So what else might happen when the lease is breached? A lockout. Your landlord cannot intentionally lock you out unless they are doing bona fide repairs, there is construction or an emergency, unless they are removing contents abandoned by the tenant, or if you're behind on rent and the right to change the locks is in the lease and they have given you notice. And the property code provision is 92008. Utility shutoffs. They can't turn off your power, okay? They can't turn off your power unless they are doing repairs, construction, or an emergency, or it's authorized by the property codes and all the requirements are strictly followed. The purpose of a lockout is to gain the tenant's attention. It is not supposed to be to lock you out. It is supposed to be for the tenant who is hiding from the landlord and the landlord can never find them to have a conversation with them. So if I lock you out of your apartment, you have to contact me. And at that point, hopefully we can have a conversation. Even if you're behind on your rent, you have the right to get back into your apartment and you have the right to get your utilities turned back on. These are ex parte lawsuits, meaning they are just between you and the judge. Your landlord probably will not be there and your landlord does not have to be there. You can do a writ of reentry for being locked out and a writ of restoration if your utilities are shut off. You have to file this lawsuit in the precinct where you live. So if you're in precinct 1, you have to file your lawsuit in precinct 1. You can't afford to pay the court costs. You can, again, get that petition filed with an inability to afford costs form that we talked about earlier. When you've been locked out, once you make a request to your landlord, within 2 hours, they have to let you back in to your unit. They cannot demand payment. You have an absolute right to be let back into your apartment after 2 hours. And this is not one of those situations where they let you in, but then don't give you a key or don't give you any way to get in and out. They have to actually give you the key if they have changed the lock. If they put a boot on it, they have to take the boot off. And they have to do this within 2 hours. You can file the writ of reentry, stating the facts of your case under oath. The case goes in front of a judge and you don't have to serve your landlord. Again, this is between you and the judge. The judge agrees, you'll get what's called a writ of reentry that orders your landlord to let you into the home, and then you serve the writ on your landlord. If the landlord doesn't let you in within the 2 hours, there are damages. You can get a month of rent plus $1,000, court cost, and fees, less whatever you owe your landlord. So a lot of times, if they lock you out improperly, they might end up offsetting the amount of rent that you may owe them. There's also an option to terminate your lease. And again, the property code section is 92008. For utilities, it's a pretty similar process. You file a writ of restoration lawsuit in the precinct. You state the facts under oath. It's another ex parte hearing. You'll get a writ of restoration if the judge rules for you. You serve the writ on your landlord, and you can also get damages in this situation as well. Your security deposit is a whole separate issue under the property code. It's in chapter 92. Your landlord can deduct from the security deposit damages and charges for which the tenant is liable. They have an obligation to refund the deposit on or before the 30th day after the tenant leaves. So you have to give your landlord a good forwarding address and give it to them in writing. Your landlord cannot retain any portion to cover normal wear and tear. You're going to want to check any kind of itemized statement they give you, because I have seen lots of landlords charge for carpet cleaning. They really shouldn't be able to do that. Carpet cleaning is normal wear and tear. And they are not allowed to keep your deposit unless you actually owe rent and there's no controversy about the amount of rent owed. So just some tips. Talk to your landlord as soon as you have a problem, as soon as you possibly can. Rental assistance may still be available, so you're going to want to check local organizations. If you're having issues with the condition of the unit, pay your rent and then contact someone for help. Remember that you need to send that notice to your landlord by certified mail, explicitly saying what's wrong with the unit and what problems you're having and what you need fixed. Thank you. These are some eviction resources, and you can also go to Texas Law Help to apply. You can go to lonestarlegal.org or call either one of these numbers.
Okay. Let me double check the chat to see if we have any other questions in there. I do not. I had a quick question for you though. So again, this is your opportunity. If you all do have any questions, please feel free to type your question into the chat. Otherwise, you can just raise your hand and unmute yourself and ask your questions directly. I am also following up on social media too, just to make sure, but I don't see anything there. Um, in all actuality, everybody's doing everything that they're supposed to. What's the general time frame from the initial notice to vacate to the time somebody's actually evicted and removed from the unit? What kind of time, assuming no appeal, but what's that time frame realistically look like?
So if there's no appeal, typically the landlord will send you the notice to vacate. Let's suppose you have your 3 days. And then they go down to court and they file the lawsuit. Within that week, you will be served at some point, and then probably within another week, you'll have a hearing. So I would say, you know,
And
10,
then
10
how long after the hearing then do they get the notice from constable? You got
so after your hearing, if the tenant loses and no appeal, right? You said no appeal. So 5 days after the tenant loses, the writ of possession can issue. It'll issue on the 6th day. So on the 6th day, the writ of possession can issue, and at that point, at any time, the constable can come out and put a 24-hour notice to vacate on your door. And so it's a really short process, right? We're talking, 14 to 20 days from start to finish.
okay.
Once you
Uh,
have court, though, if you don't appeal in 5 days, on that 6th day, the constable can get that writ. And once they have the writ, they will show up and put that notice on your door.
and then the date, is it like the day after the notice, or how many days after they
They
get the notice on the
typically
door?
they typically give you a 24-hour notice.
24 hours.
Yeah.
Okay. So we're looking at probably roughly a 3-week process,
From start to finish,
start to
yeah,
finish, about 3 weeks. Okay.
about 3
So
weeks.
I just wanted to kind of get a time frame for a lot of folks that, again, like in the beginning, I had mentioned that sometimes people think when they get the notice to vacate that that means you have to leave like right then, as opposed to, okay, it starts now, you've gotten the notice, but you still have actually a couple of weeks. It's not within a matter of, you only have 3 days, 5 days, or whatever to completely vacate. There's still a
Yes.
process that they
So
have to go through. Okay.
you do not have to leave once you get the notice to vacate. They still have to take you to eviction court and get an order from a judge saying that you have to leave. So they still have to follow that legal process.
So you can be evicted without necessarily owing rent,
You
per
can be
se,
evicted for not, even if you're current on your
for other
rent,
reasons.
but those are going to be things for that we call material breaches. So
Hmm.
that's what I said, having a party is not going to be a material breach. But if you're having a party every single Friday and Saturday night, and the cops come out every single Friday and Saturday night, and this happens for 2 months, right? That is probably more of a material breach. You're talking about something small that's not a big deal. But if you're talking, and it's not, I can't give you like a clear cut answer of what's a material breach, but like, I think most people would agree that if the cops come out to your unit every single Friday and Saturday for 2 months, you've crossed a line. Like that's right versus just one time and then you're behaving yourself.
Can they still charge you for or some kind of a fee for the remaining balance of your lease? So say, for instance, you're only 6 months, 8 months into your lease, but you signed for an entire year.
They
Charge
are
you some kind of a fee for the remaining balance of your
they
rent,
are
even though they asked you to leave.
they are supposed to mitigate, meaning they are supposed to, if you are evicted, they are supposed to do their best to fill that unit again so that you're not responsible for so whatever rent they would have lost under the contract, they're getting from somebody else. But if they can't fill that unit, you still signed a contract that said, I will pay you, for example, $1,000 every month for 12 months, right? So you still owe them the money under that contract, even if you're not in possession of the unit.
Wow. Even though the cost is in exchange for the space, if I'm not in the space, I still owe you money if I'm not even there.
If you are the reason you are not in the space, then you are responsible.
Gotcha. Okay, there's a few questions that popped up in the chat here. Once at court, will they be willing to give you a few days if you know you will have the funds? I was unemployed, which is why I fell behind, but I have a new job to catch up, and now I'm able to catch up. Is it possible that the court will grant them that extra time?
It is possible. Um, the issue is that once you are behind, the landlord is under no legal obligation to take your rent. So it's a lot of it's going to depend on the kind of relationship that you have with your landlord. If you are able to have those funds before you get to court, I would offer them to the landlord in exchange for a dismissal. You also probably will have a better chance with a lot of judges if you show up with the money and say, I have the money, but they won't take it. Because I have seen more than one judge look at them and say, really, you're not going to take the rent? But they don't have to. They are under no legal obligation to, which is where it comes into a problem.
Hmm. Would you recommend that if somebody like in a situation like this where I've only got part of the money now, still make the payment of whatever that it is if the landlord is willing to accept it, or
If
just
you,
not pay the total in full?
it's a little tricky, right? Because if your landlord's willing to work with you, that is probably easier, right? But I would hate to say, let's suppose you have $500. I would hate for you to give your landlord $500 and then you're going to be evicted in 15 days and you needed that $500 to move.
Okay.
And so there's a lot of considerations there. Hopefully you will know if your landlord would be willing to work with you. There are some landlords that will take the money because it's a piece of what you owe them. There are some landlords that will say, I don't want your money, I want you to move. And so it just depends.
Now, if they accept a partial payment, does that then become like well, well, you agreed to take a partial payment in order for me to stay here, then you accepted the money. So if I accept the money, I still don't necessarily have to allow you to stay there.
Correct. Because you owe them the money. Don't
Okay.
forget that you signed a contract saying you would pay this amount of money. And so just because they're letting you pay it in chunks, you still owe the money. You're still behind.
Even if like in a text message or email, they agree, okay, I'll accept partial payment and you pay the balance by X day or whatever.
You might be able to use that. The problem is a lot of contracts have no waiver language in them, which says that just because I agree to let you do something now doesn't mean I'm letting you do it later, and it doesn't change any of the rights or privileges under this contract. Right. And so some landlords will say, I'll let you pay but unless you have that in writing, unless you have proof, you're gonna have a really hard time altering any parts of your contract.
Hmm. Okay. If you simply need more time to pack up and leave the premises, can you state that in your hearing, due to an illness, disabled children, etc.?
So the justice court, you can always state whatever you feel is relevant to your case. They are not legally required to give you more time. The code's very specific. You have 5 days to appeal, then 5 days to pay your rent, and then it goes into county court. And you'll get your hearing. The cases are moving pretty quickly nowadays. So 2, maybe 3 weeks, you'll have your hearing in county court. Again, it's one of those things where you hope that your landlord will give you a little more time, but they don't have to. There are some judges that will push the writ date out, so they'll give you 10 days before the writ will issue instead of 5. But it's really just a matter of what you can negotiate with your landlord. The code does not require that.
So ask, basically, if all else fails, just ask, because you never know who's gonna, accept an offer. Just don't avoid them or don't talk to them, don't communicate. Ask
Right,
the question, because if how do you say
right,
closed mouth don't get fed. So if you don't ask, then you never know. That the worst that they can say is no, and you already know what you're facing anyway.
right.
So what's the harm in at least asking?
Yes.
Okay. Let's see. We're taking paperwork of being on unemployment and now getting a new check stub help
I'm not sure what that is in
in
reference.
relation to the person that was unemployed now has a job and needing more time to make the payment. Would that
Yep.
help their
I think
case?
it's I think it's what you just said. Ask. In Texas, the law is written pretty favorable towards landlords. And so the best thing that you can do is ask and try to work something out with your landlord.
Okay. Um, what was it? Okay, what is the wisdom underlying the requirement that citizens needing rental assistance must have waited until they are facing eviction? I'm not sure what that means. I'm assuming
I think for a lot of
when do they
rental
reach out?
assistance,
When do they reach out and ask for assistance, maybe?
I
Or
think a lot of rental assistance programs won't pay out until you're actually facing eviction, until you've gotten more than a notice to vacate, until you've actually had a lawsuit served against you.
okay,
My understanding that is done because the volume of people that need assistance is astronomical, and people that are actually served with the eviction are facing the most imminent threat of homelessness versus people who have not yet received that lawsuit. There's always a chance that someone who has not yet been served would be able to work something out with their landlord versus someone who has already been sued. That chance is a lot smaller.
are you all aware of any? Because I know funds are very extremely limited now everywhere, even prior to the whole COVID and moratorium, funds were kind of starting to dwindle down. But there used to be, a key set of folks that would have some form of rental assistance. Are there that you are aware of programs that are out there that are help with making rent payments?
Um, we typically send people to the county, to be honest, to apply for any rental assistance they have. Judge Jubal, and I'm gonna get this wrong. I want to say Judge Lozano, they have coordinators in their courts that help with resources. And so if you are they're in pilot programs right now, so it's a very limited court. So they have resource coordinators that I think can help try to track down resources. But for the most part, we send people to the county.
I was just at United Way had one of their partner showcase meetings, and there was somebody there from the court that said that they are in the basement level of one of the Justice of the Peace courts or something like that, where they are helping people with assistance. I have to find that flyer. If I find that flyer, I will attach it to the email that I send out to folks. So I mean, when I send
I
this
know
email out,
Judge Dubel is one of them, but I can't remember where the other pilot program is off the top of my head.
okay, all right. Let's see. Are there any other questions from any other participants that are joining us? I don't see anything online here. I've been kind of watching both. And the one question that I asked about the when should they ask was the question that was emailed to me prior to. So I don't see anything else. Um, in your most recent cases and things, um, what's been the biggest the most common thing that you have seen that tenants don't do as it relates to evictions, or the common thread or the common mistake that a lot of renters make when it comes to them facing eviction?
So I think there's a couple of things. I think renters on the whole wait too long to reach out to their landlords to see if there's any way to set up a payment plan or catch up. If you have to do that repeatedly, it becomes a problem. But if you've been there for a minute and this is your first time to do that, a lot of landlords are willing to work with you if you have a history of paying your rent on time. So I think one of the biggest things we see are people that wait too long to talk to their landlords. We see people move when they get notice to vacates before the eviction is ever filed. You don't have to do that. You can wait until the eviction is filed. Now, if this is going to be the very first eviction on your record, it might be worth it to you to move before an eviction is filed, because once an eviction is on your record, it makes it a lot harder to rent again. But if you've already have evictions on your record, I would think really carefully about whether you're just going to leave before you're actually evicted. We still see people withholding rent. That's still a big one. Instead of asking for repairs, they just stop paying their rent because there's an issue that needs to be fixed in their units.
Um, in previous presentations too, we've talked about things that a landlord, what's legally can a landlord go into a tenant or residence and like take property?
So you have to have a provision in your lease that allows for what is called a landlord's lien. So that provision will typically say if you tenant don't pay rent, then I have the right to go into your apartment and take basically items that are worth money, but that you don't need to live or work, right? So they can't take your medical equipment. They probably can't take your computers because computers are necessary for work now. What they can take, and they will take, is your giant screen television. They'll take your Game Boy or whatever gaming system you have, your Nintendo Switch, whatever it is. And you'll see a giant notice where your TV used to be that says, we took your television pursuant to a landlord's lien to pay your rent. And they'll
Do
hold it until you either pay the rent or they sell it and apply it to your account.
do most standard TAA leases have that kind of
They
provision in
do.
there? They
They
do.
do.
Okay.
I've very rarely seen a landlord execute a landlord's lien just because the value of electronics decreases so quickly.
Fast.
The item is purchased, right? And things are not as expensive as they used to be. There was a time where that 30-inch flat screen television was $600. Well, now that 30-inch flat screen television is, $75 on sale, right? And so you're not going to sell it for anything.
So it's not even worth the hassle for them to actually come in here.
Yeah, so it's a lot. And also, you also have to know, there's no way you don't know that that television's not being financed. So you might sell it only to turn around and have to give the finance company the money.
Mm, okay. All right. Well, I don't see anything else. I believe that is just about it, Sakna. I really appreciate you filling in for your counterparts
Of
and
course.
providing the information. I know they're tied up in court, and especially with the way things are right now, I was surprised that you guys were even available today to even still come out and participate because I know that this is kind of on the low end of the spectrum as far as people that are actually out there that are facing
No,
eviction that
no,
they're
no,
trying
no.
to help. Like, right.
It's
I don't
important.
mean low end, but it's important. But the fact that you guys are limited in staff and then you've got so many people that are out there that then to stop and then still take the time out to do this, it is greatly appreciated.
You're very
Greatly,
welcome.
greatly appreciated. So
Important that
thank
people
y'all
know
very
their
much.
rights.
Absolutely, absolutely. And again, we want to try to provide the most up-to-date information that we possibly can from you all directly. I may hear some things or find some things out or whatever, but I'd rather you all say it than me because I'm not the attorney. It's definitely most beneficial coming from you guys as you can speak on the line. I can. So we want to thank everybody for participating and attending this presentation this afternoon. Again, if there are any questions that you have, or even if you guys come across any resources that you would like to share, if you all know of some place that's providing rental assistance, utility assistance, please reach out to me and let me know because we do these presentations, we get calls so often of people looking for something, and we want to try to create our own little resource list. And I know people go to United Way sometimes looking for a lot of information, but United Way's lists sometimes are not as up to date because they actually have us on their list as a organization that provides rental assistance, and we don't.
Right.
Because we do the eviction workshops, they just see evictions and automatically assume that we're providing those services. So, and I know again, funds kind of fluctuate between somebody that may be offering this month, may not be offering next month, or may not have the funds next month. But if you guys know of something, then please let us know so that we can inform community members as they're calling and they are in need of services that will at least can kind of give them some reference to actually go to when they need assistance. So
Absolutely.
again, thank you all very much for your participation. I will be sending out the link of this recording along with any resources and links that I may come across or have available. I will definitely try to find that flyer about the rental assistance through the courts and attach that to the email correspondence that goes out to everybody as well. So we'll be back next month, the third Tuesday of next month at 1 p.m. Um, for our next presentation with you all. So thank y'all very much. Hope you all have a wonderful remainder of your afternoon. Take care of yourselves and stay safe, and we will see y'all next time.
Thank you.
All right, thank you very much.